The Malevolent Jobholder by H.L. Mencken. From the American Mercury, June 1924. This was written long before the New Deal afflicted the country with a great mass of new administrative law and a huge horde of new and extra-tyrannical jobholders. I am more than ever convinced that it embodies a good idea. In the immoral monarchies of the continent of Europe, now happily abolished by God's will, there was, in the old days of sin, an intelligent and effective way of dealing with delinquent officials. Not only were they subject, when taken in downright corruption, to the ordinary processes of the criminal laws, in addition they were liable to prosecution in special courts for such offenses as were peculiar to their offices. In this business, the abominable Prussian state, though founded by Satan, took the lead. It maintained a tribunal in Berlin that devoted itself wholly to the trial of officials accused of malfeasance, corruption, tyranny, and incompetence, and any citizen was free to lodge a complaint with the learned judges. The trial was public, and in accord with rules fixed by law. An official found guilty could be punished summarily and in a dozen different ways. He could be reprimanded, reduced in rank, suspended from office for a definite period, transferred to a less desirable job, removed from the rolls altogether, fined, or sent to jail. If he was removed from office, he could be deprived of his right to a pension in addition, or fined or jailed in addition. He could be made to pay damages to any citizen he had injured, or to apologize publicly. All this, remember, was in addition to his liability under the ordinary law, and the statutes specifically provided that he could be punished twice for the same offense, once in the ordinary courts and once in the administrative court. Thus, a Prussian official who assaulted a citizen, invaded his house without a warrant, or seized his property without process of law, could be deprived of his office and fined heavily by the administrative court, sent to jail by an ordinary court, and forced to pay damages to his victim by either or both. Had a Prussian judge in those far-off days of despotism, overcome by a brainstorm of Kaiserlich passion, done any of the high-handed and irrational things that our own judges, federal and state, do almost every day, an aggrieved citizen might have haled him before the administrative court and recovered heavy damages from him, besides enjoying the felicity of seeing him transferred to some dismal swamp in East Prussia to listen all day to the unintelligible perjury of anthropoid Poles. The law specifically provided that responsible officials should be punished, not more leniently than subordinate or ordinary offenders, but more severely. If a corrupt policeman got 6 months, a corrupt chief of police got 2 years. More, these statutes were enforced with Prussian barbarity, and the jails were constantly full of errant officials. I do not propose, of course, that such medieval laws be set up in the United States. We have indeed gone far enough in imitating the Prussians already. If we were to go much farther, the moral and enlightened nations of the world would have to unite in a crusade to put us down. As a matter of fact, the Prussian scheme would probably prove ineffective to the Republic, if only because it involved setting up one gang of jobholders to judge and punish another gang. It worked very well in Prussia before the country was civilized by force of arms, because, as everyone knows, a Prussian official was trained in ferocity from infancy and regarded every man arraigned before him, whether a fellow official or not, as guilty ipso facto. In fact, any thought of a prisoner's possible innocence was abhorrent to him as a reflection upon the politie, and by inference upon the throne, the whole monarchical idea, and God. But in America, even if they had no other sentiment in common, which would be rarely, judge and prisoner would often be fellow Democrats or fellow Republicans, and hence jointly interested in protecting their party against scandal in its members against the loss of their jobs. Moreover, the Prussian system had another plain defect. The punishments it provided were, in the main, platitudinous and banal. They lacked dramatic quality, and they lacked ingenuity and appropriateness. To punish a judge taken in judicial crim con by fining him or sending him to jail is a bit too facile and obvious. What is needed is a system, A, that does not depend for its execution upon the goodwill of fellow job holders, and B, that provides swift, certain, and unpedantic punishments, each fitted neatly to its crime. I announce, without further ado, that such a system, after due prayer, I have devised. It is simple, it is unhackneyed, and I believe that it would work. It is divided into two halves. The first half takes the detection and punishment of the crimes of job holders away from courts of impeachment, congressional smelling committees, and all other existing agencies, i.e., away from other job holders, and vests it in the whole body of free citizens, male and female. The second half provides that any member of that body, having looked into the acts of a job holder and found him delinquent, may punish him instantly and on the spot, and in any manner that seems appropriate and convenient, and that, in case this punishment involves physical damage to the job holder, the ensuing inquiry by the grand jury or coroner shall confine itself strictly to the question whether the job holder deserved what he got. In other words, I propose that it shall be no longer malum in se for a citizen to pummel, cowhide, kick, gouge, cut, wound, bruise, maim, burn, club, bastinado, flay, or even to lynch a job holder, and that it shall be malum prohibitum only to the extent that the punishment exceeds the job holder's deserts. The amount of this excess, if any, may be determined very conveniently by a petite jury, as other questions of guilt are now determined. The flogged judge or congressman or other job holder, on being discharged from hospital, or his chief heir in case he has perished, goes before a grand jury and makes complaint, and if a true bill is found, a petite jury is impaneled, and all the evidence is put before it. If it decides that the job holder deserves the punishment inflicted upon him, the citizen who inflicted is acquitted with honor. If, on the contrary, it decides that this punishment was excessive, that the citizen is adjudged guilty of assault, mayhem, murder, or whatever it is, in a degree apportioned to the difference between what the job holder deserved and what he got, the punishment for that excess follows in the usual course. The advantages of this plan, I believe, are too patent to need argument. At one stroke it removes all the legal impediments which now make the punishment of a recreant job holder so hopeless a process, and enormously widens the range of possible penalties. They are now stiff and, in large measure, illogical. Under the system I propose, they would be made to fit the crime precisely. Say a citizen today becomes convinced that a certain judge is a jackass, that his legal learning is defective, his sense of justice atrophied, and his conduct of cases before him tyrannical and against decency. As things stand, it is impossible to do anything about it. A judge cannot be impeached on the mere ground that he is a jackass. The process is far too costly and cumbersome, and there are too many judges liable to the charge. Nor is anything to be gained by denouncing him publicly and urging all good citizens to vote against him when he comes up for re-election, for his term may run for 10 or 15 years, and even if it expires tomorrow and he is defeated, the chances are good that his successor will be quite as bad, and maybe even worse. Moreover, if he is a federal judge, he never comes up for re-election at all, for once he has been appointed by the President of the United States, on the advice of his more influential clients, and with the consent of their agents in the Senate, he is safe until he is so far gone in senility that he has to be propped on the bench with pillows. But now imagine any citizen free to approach him in open court and pull his nose, or even, in aggravated cases, to cut off his ears, throw him out the window, or knock him in the head with an axe. How vastly more attentive he would be to his duties! How diligently he would apply himself to the study of the law! How careful he would be about the rights of litigants before him! How polite and even suave he would become! For judges, like all the rest of us, are vain fellows. They do not enjoy having their noses pulled. The ignominy resident in the operation would not be abated by the subsequent trial of the puller. Even if he could be convicted and jailed, the fact would still be brilliantly remembered that at least one citizen had deemed the judge sufficiently a malefactor to punish him publicly, and to risk going to jail for it. A dozen such episodes, and the career of any judge would be ruined, and his heart broken, even though the jails bulged with his critics. He could not maintain his air of aloof dignity on the bench. Even his catchpoles would snicker at him behind their hands, especially if he showed a cauliflower ear, a black eye, or a scar on his bald head. Moreover, soon or late, some citizen who had had at him would be acquitted by a petite jury, and then, obviously, he would have to retire. It might be provided by law, indeed, that he should be compelled to retire in that case, that an acquittal would automatically vacate the office of the offending job holder.